In this training module, I'm going to explain the two general sides to patent rights and the three primary perspectives that patent attorneys use to think about inventions. This includes discussing how patent rights are obtained versus how patent rights are enforced. By the end of this training module, you should be able to understand why talking to patent attorneys about your invention is sometimes harder than you expect, because they, or we, are always trying to compartmentalize the discussion into separate perspectives. Let's get started. The first thing to note is that there are really two sides to the patent discussion. One is about getting a patent. We call this side procurement. Just like when you go out and you get a supplier or a vendor and you buy materials or inventory from somebody, you procure those supplies or that inventory from them. It's the same in the patent world. You need to go out and you need to procure your own patent rights. You need to go through the process of obtaining those patent rights. The other side is called infringement. This has nothing to do really with the ability to get a patent. Rather, it has everything to do with whether or not somebody is unauthorized in the use of somebody else's invention. Let's look at these each in a little bit more detail. So the fundamental questions regarding procurement or obtaining patent rights are the following. You want to look and see if you can actually get a patent. And we're going to go through some of the steps in the workshop later on in other modules about how to determine if you can get a patent on your invention. You also are going to be very interested as to what scope of protection you can get. Can you get a patent specifically that covers your invention? You'd be surprised how many times people are able to obtain a patent only to later find out, or perhaps maybe never find out, that that patent has claims that don't actually cover their invention. It covers a different invention, but not the product that they're actually making and marketing. Another question related to obtaining patent rights is, can you get a patent that protects against competing technology? This would be something that goes beyond just the commercial embodiment that you're planning to make yourself or that you're planning to license to somebody else. And it would include additional broader variants of your invention that you've described, even though you're not necessarily planning to make them or license them to other people. A last question related to obtaining patent rights is there a possibility that your patent rights could be invalid or invalidated? And that usually comes into play when you start to assert that against other people, and they don't want you to assert it against them, so they start to challenge whether or not you should have ever been given the patent rights in the first place. These questions altogether are what you're normally thinking of when you think about patent rights. How can I get a patent? What will it cover? Will it cover my invention? How can I stop other people from using it? How broad will it be? And what, if anything, might threaten the validity of my patent? This diagram is kind of interesting because it helps to show some of the alignment or sometimes misalignment that happens between what an inventor thinks that they're trying to protect and what they're actually protecting when they go forward with a non-provisional patent application and they draft claims toward an invention that isn't necessarily the same as what their commercial embodiment is that they initially came up with. So when you have a patent application, and we'll get into these details more in later modules, you're going to start with a technical specification, something that you or another inventor has come up with to describe the technical features, structures, functions of your invention. From those technical specifications, we're going to draft a patent specification, and it won't look like the technical specifications in a lot of ways. Rather, it'll be complying with the formal requirements to obtain a patent application and an issued patent. So that patent specification will describe and probably overlap substantially with the technical specifications that you've created. However, it also might go beyond the technical specifications to describe broader variants. Likewise, when we get into the later parts of the provisional patent application, if you decide to use patent claims, or definitely once you get into the non-provisional patent application process, you'll have to include patent claims at that point. And then there's another opportunity for alignment or perhaps misalignment of your patent claims with the patent specification and also with the technical specifications. The area where all of these three different zones overlap is what I call patent productivity. It means that you're actually aligned in all three regards and overlapping and covering what your invention truly is intended to be. We might look at this graph again in another module when we start thinking about what do the different zones outside of the patent productivity zone look like. Are they useful? Are they harmful? We can get into that in later modules. In contrast to the procurement side, or the side of obtaining a patent, is the side of infringement or enforcing the patent rights. And this we need to break into two different categories. The first is your enforcement of your patent rights against other people. The second is very similar, but from the opposite perspective, which is, can other people enforce their patent rights against you? Let's look at the following diagrams to help illustrate the differences between infringement and procurement. When somebody has patent claims on an invention, illustrated here by the red circle, those claims define the scope of protection that they have so that they can exclude somebody else from making or using their claimed invention. When somebody comes in with a competing product, and by competing I mean it overlaps with some or all of the patent claims, the person who owns the patent has the right, although not the obligation, but has the right to enforce their patent claims against the infringing product. That's, of course, called patent infringement. We mentioned that there are two different scenarios. One is you might be the owner of the patent claims, and you might have a competitor or another person who develops and is using or is selling a competing product that overlaps with your patent claims. In this instance, you would have the right to stop them from performing any of those functions or selling a product that is in the overlapping space with your patent claims. That doesn't mean that you could stop them necessarily from competing in the area outside of your patent claims, although there are some circumstances where that's possible. In this diagram, we look at the scenario where you still have the same patent claims designated by the red circle. However, sometimes your claims are broader than the claims that somebody else has because you've come up with a new improvement on their invention. Let's say that somebody's invented a specific type of material that's useful in the tip of a shovel because it's extremely hard. If you come up with a new shovel that has different handle structures or different features on it that have never been out there, but you choose to use in your product their new material that they have a separate patent on, then you could have a scenario like this where your product falls completely within the claims of your own patent application, but also simultaneously infringes potentially on the patent rights of another person because you've incorporated their invention into part of your invention. This is a scenario where you start thinking about whether or not you can actually go out and make your own invention. When we start looking at the differences between these three scenarios, including first, procuring your own patent rights, second, enforcing your patent rights against someone else, and third, having someone else enforce their patent rights against you, we can start to distinguish between these scenarios from a purely financial perspective. Often you'll find people say, in order to get a patent, it might cost you $10,000, $20,000, $30,000, depending on a lot of different factors. And that's the total cost. You can usually get started for a lot less than that, which is usually the number that the patent attorneys will give you up front, if they don't give you the full cost up front. But you might be able to get in for, let's say, $20,000 and plan on getting a patent for about that amount total. In contrast, when you start looking at initiating a lawsuit against somebody else for infringing your patent, the number that people are often saying currently that it costs to enforce your patent is in the neighborhood of $1 to $1.5 million for each claim that you assert against somebody else. So if you start thinking about multiple claims in a single patent and trying to assert 5 or 6 claims against somebody else, those numbers add up really fast and also present the reason why many inventors hesitate trying to enforce their patents up front, or maybe even hesitate trying to get a patent because they feel like it's a hopeless situation if they try to enforce it against somebody else. That's not necessarily the case for a well-written patent, but it certainly can be cost prohibitive in a lot of instances if somebody's not ready to take a strategic approach to enforcing their patent rights. Likewise, when you look at the third scenario of somebody else suing you for potential patent infringement, you end up again with very large financial commitments, with the additional disadvantage that typically somebody defending against patent infringement doesn't have the right or the possibility of collecting fees for their attorney's costs if they win the suit. They simply win the right to continue making their product and not getting sued again. I don't want to get too far down that road talking about costs and everything else, because right now what we're really focusing on is simply getting a provisional patent application filed so that you can then determine if there's a viable business model that will support deployment or commercialization of your invention, either by making it yourself or by licensing it to somebody else. What we really need to do at this stage is simply focus on that provisional. If we do end up determining that there's a business model after we've filed the provisional and done some more market research, then we can start to worry about how do we enforce this? How do we write a patent that truly is enforceable? And we rely on the fact that we have done the market research to justify the costs that we anticipate might be incurred. So let's not get ahead of ourselves. Let's focus right now on the provisional patent application process. I just want to give you a heads up and give you a broader perspective. There are different ways to look at the patent process, and when you start talking to a patent attorney at some point in the future, you'll want to be able to speak to that patent attorney in terms of the patentability side of your invention, the enforcement side of your invention, and also the potential enforcement side of somebody else's patent against the product that you ultimately end up making. That's it. You should now be able to think about the different impacts the procurement and enforcement sides of patent rights might have on your innovation process.